welcome back to One-on-One Shadowboxing, Have Your Say. In this part of the episode, now we're talking to Rodney Colleton, a farmer from
Williams,
and also a businessman. The discussion is still about money and the banks. Rodney, what's your story and experience?
Okay, well look, thanks for giving us the opportunity to come and have a chat. But look, we've just come out of a major battle or a litigation. I have 3 companies, but as a director of one of the particular companies is that you must do whatever it takes to protect your assets of that company. So we put a patent on this. I am an inventor on...
Method?
Yes. And we put a patent on there. We then found that someone had copied that product, the grain keg, and then we wrote to our lawyers and said, look, we've been infringed, we may have been infringed on our patent.
Yes.
What is the next step? And they then turned around and said, well, we need to write them a letter. So we wrote them a letter. So what happens then is that the people can either come, the other parties can either come to the party and have a chat,
yes,
commercially chat, which is what we asked them to do, or they can just push a button and commence a class action in the Federal Court of Australia for what they call an unjustified threat, and that's what this party did. So basically it was a number of parties. So we stood up and fight, and we won that, and the costs of that litigation were $914,000, but it's still ongoing. And look,
how big is the farm?
We've farmed, it's about 2,500 acres. We nearly got into going into another area of taking it to 13,000 acres,
yes.
But that didn't eventuate, and that was part of the reason through the patency, because the patency brought on such a huge cost. And look, so in our case with the farm, we basically had Landmark come to us and look at being a partner in the grain keg concept. And look,
So you got money from Landmark, finally?
Yeah, and what then happened was, that was okay, and then there was this takeover. Yes, so what then happened was there were no bank managers. So our bank manager that we were
dealing with,
well, they had all abandoned the ship, and so we were ringing in, and there was no answer. And
you called whom?
Landmark. So everyone had bailed ship. So we basically didn't have a point of contact, which was very, very frustrating. So in the end, we managed to, because I know quite a few people in the industry, managed to get through to someone, and they said, oh, you know, we're very apologetic. Look, all our managers have left, and we will have someone come to you shortly. We had a ANZ gentleman come down the driveway, and he said that everything will be the same. There'll be new paperwork come out. It's just a simple transfer, to ANZ. Securities would be the same. Nothing had changed. So anyway, when the documents were delivered to us, they weren't the same. They were asking for total security over the intellectual property of the grain keg, which was never a requirement with the previous lending, and we rejected that. And also, we basically then said to them, at this stage, refinancing is going to be difficult because we have court action through the patent action, and no bank, no financial institution
will give you
money. It's
we,
you know, look, we didn't, and that wasn't an option. So what?
And wasn't even an intention from you to change.
No, and look, and we said if that's the case, you know, depending on what their reply was, because there's 2 sides to every story. We then said, well, what would your position be? And if we do get refinance, we would want a guarantee that we are paying out PCL, because that's the permanent custodians were the title, the mortgagee on our titles of R&I Culleton, and we would need reassurance that if we
They're
paid
not
out
coming.
if we paid out an agent, that PCL wouldn't come down the track and say, well, that's okay, you paid them, but you should have paid us and whatever, because and they didn't give us that. They wouldn't give it to us. So I refused to sign. So basically, the correspondence was then, if you don't sign, you're out. And we then had a Roland Davis from the lending services, which I class as the FO department of a bank, and he then just got very, very aggressive, and to the end where basically he pulled on the heavies. He put in this big affidavit and commenced action, and he gave us no comfort whatsoever. And so then
Well, they wanted to get the money back from
Well,
you.
that's right. They served a writ on us. So what we did, it was in front of a registrar, Whitebread, in the Supreme Court.
Yeah.
And so we basically went to that court, and because it was in front of a registrar, we went there both with the company and in our personal capacity. And because we just thought it was a directions hearing, we were under the impression it was a directions hearing. Because
to hear both sides and decide what is.
In other jurisdictions around Australia, given my knowledge, they don't have registrars do the final judgment. And that's why we never had legal representation on that day, because we honestly were under the opinion it was a directions hearing. So when we turned up, we were totally wrong. And basically the hammer came down. The registrar would not allow us to talk. She said that we had to have representation, which was not correct, because we were there in our own capacity, because we actually appeared on the title. We were actually people that borrowed the money off PCL.
So you're representing yourself, of course, because you are the one.
That's right. But I just said to my wife, I've just made a big mistake here. This is not justice. So we then turned around and said, we need to go and get legal representation, obviously. And when we went, and by the time we sort of had a couple of days to get over it, when we did go to get advice, a registrar appears to there is only a 3-day appeal process for a registrar. So, which...
Technically,
yes, and look, I had
screwed up again.
Yeah, I went to Parliament House and had a meeting with the Attorney General, and I actually asked him what is the appeal process for a registrar, and he actually answered it was 28 days. And I said, well, 28 days is pretty good. You know, could it be 14? Well, he said, well, I don't think so, but it may be. But it wouldn't be any less than that, would it? He said, oh, no. And I said, well, try 3 days. And he just sort of stepped back and said, I didn't know that. So had that hearing been on Friday, by Monday morning, it's a bit like someone pulling out the chainsaw and cutting down a 60-year-old tree. Takes 2 seconds, doesn't it? Yes. But the 60-year-old tree's taken a good 60 years to grow. And that's really what happened to our one part of our project, and it was very disappointing.
So you has no chance to appeal?
No, we're out of time. So they lent us 1.6 million to buy a piece of property 12 months before, and then when ANZ come, they're trying to take it off me. So I don't know, and I didn't even get my financials into them that year, so I don't know how they come all about that. Okay, so 1 minute you're good, next minute, oh no, because you're not giving us intellectual property. Which
has nothing to do with each other.
Absolutely. Never was an original standard of the contract.
Well,
terms and condition. Okay.
It's nice talking to you.
No, nice to talk to you, and thanks for the opportunity.
Learn your story. On that note, we have to go to a short break, but please stay with us, because in the third part, we're coming back with more discussion on this PCL INZ saga.